Thank you. Good morning, everyone. I'm going to call the Assembly Committee on Judiciary to order this morning. Madam Secretary, would you please call the roll?
Assemblywoman Bilberry Axelrod. I cannot hear.
She is not. She is here, but she's not at her desk for the moment, so I think that's why you're not hearing her.
Oh, thank you. Assemblywoman Cohen.
Here.
Assemblywoman Gonzalez.
Here.
Assemblywoman Hanson.
I'll let them know. Yeah. Okay.
Assemblywoman Hanson. Assemblywoman Hardy.
Here.
Assemblywoman Kasama.
Here.
Assemblywoman Krasner.
Here.
Assemblywoman Marzola.
Here.
Assemblyman Miller.
Here.
Assemblywoman Wynn.
Here.
Assemblyman O'Neill.
Here.
Assemblyman Orntlicker.
Here.
Assemblywoman Summers Armstrong.
Here.
Assemblyman Wheeler.
Here.
Chairman Yeager.
Here, and Assemblywoman Bilberry Axelrod is present. She just ran down the hall to deliver some headphones, so she is here. Please note that for the record. I think the only member we're missing then would be Assemblywoman Hanson, and please mark her absent excused for the time being. I do expect her to be here at some point during the meeting. That means we do have a quorum. Again, want to say good morning to committee members, to anybody who may be watching us online or on the legislature's website or YouTube channel. This is day 73 of the 81st session of the Nevada Legislature. I hope you all had a good couple days off. We'll have a few bills to get through this morning, and I don't think it'll take us too terribly long. Before we get to those bills, though, I do want to go over some basic housekeeping rules. For those of you on the Zoom with us, if you could please mute yourself when you're not speaking, that'll help with the audio feedback. If you're presenting a bill this morning, particularly when you answer questions, if you could state your name each time before you speak, that'll help prepare accurate committee minutes. And then we do expect respect and courtesy to one another in our interactions with one another. We don't always agree on policy, that's perfectly fine, but we need to make sure we're being respectful of one another, of this process, and most importantly, of our hardworking staff. And then finally, many members are using multiple devices to access this meeting, so please don't see it as a sign of disrespect or inattention if members appear to be looking away. With that behind us, members, will go to our agenda. I do intend to take the matters in order as listed on the agenda. So at this time, I will open up the hearing on Senate Bill 9. Senate Bill 9 creates an exemption from licensing requirements for investment advisors to certain private funds. And we'll welcome to the committee our Lieutenant Governor Marshall, Ms. Lopez from the Lieutenant Governor's office, and Mr. Sailing as well. So welcome to the committee, and please proceed.
Thank you, and good morning, committee members, and good morning, Chair Yeager. I hope you've had your donut this morning. I don't know if you know, but my first job was in a donut shop, so I am familiar with the morning donut. So SB 9, and thank you again for having me. Late last summer, my office was contacted by Jeff Sailing, who is here to speak to you today also. He is the founder of Startup Nevada, which is Nevada's only statewide business incubator, and provides training and resources for local entrepreneurs, both in Las Vegas and in Reno. During our conversation, Jeff conveyed the immense need to update our blue sky laws to better attract and retain early stage investment capital in Nevada. As many of you know, blue sky laws are state laws that impose standards for offering and selling securities and aim to protect individuals from fraudulent or overly speculative investment. Our current laws haven't been updated since the 1990s. At the time, they were written in alignment with federal regulation to address the dot-com boom. Both federal law and security and the Security Exchange Commission regulations have evolved significantly since then. In addition, the National American Security Administrative Advisory Board has laid out model regulations. It's the intention with SB 9 to update state law to match the North American Security Administrative Advisory recommendations and current federal law. So we are really just bringing ourselves up to date. This is in line with 23 other states, including our neighbors in Utah, Arizona, and Idaho, creating both greater modernization and competitive advantage within Nevada's entrepreneurial ecosystem. Before I turn the presentation over to Jeff Saling, I'd like to highlight a few things. Nevada has always had an issue with people, being a flyover state, people not coming here to invest in our businesses here, us not being able to raise the money beyond family and friends and your credit card so that you could start a business. In the governor's latest recovery report, one of the things it does note is that Nevada has an incredible entrepreneurial spirit, but we need to encourage and support that. There is a fiscal note on this bill of $12,375 per fiscal year. This is an estimate from the Secretary of State's office stating that they believe that they will have decreased licensing fees to the state attached to this legislation. Therefore, you will see in Section 4, subsection E of the bill, it addresses this potential decrease in revenue by giving the opportunity to the Secretary of State's office to establish a fee should they choose to make up for that revenue if in fact it occurs. The section reads that in order for an investment officer to qualify for exemption, they must pay a fee prescribed by the administrator should the administrator so choose. In this instance, the administrator is the Deputy of Securities appointed by the Secretary of State. In conversation with the Deputy of Securities, we have expressed that given that the bill authorizes the administrator to prescribe a fee, we support the department's decision to apply a fair and reasonable fee if they so choose, as this would mitigate and or negate any fiscal impact that may arise. Of course, at this time, all of this is estimates, right? We'd also like for the record to highlight that we believe that the economic activity associated with increased venture capital and business development catalyzed by the passage of this bill would significantly outpace any loss in licensing revenue the state may experience due to this exemption. Additionally, we had the pleasure of interacting with Professor Ben Edwards of UNLV. He suggested an amendment to this bill in order so that we can bypass this issue going forward and give you, the legislature, the opportunity to make decisions as federal law and model regulations evolve across the country. So this section 4.5 of the bill requires the administrator, that being the Secretary of State, to submit a biennial report to the legislature, as well as publish a report on their website. The report would include a summary of the states that have adopted any model rule, regulation, exemption, or provision of the North American Securities Administrators Association in the immediately preceding 5 years. A summary of the states that did not adopt such legislation, so you get to see the whole picture, and a determination whether the Securities Division of the Office of the Secretary of State has the resources necessary to achieve its objectives. And finally, any recommendations for legislation by the Secretary of State relating to the protection of investors in this state. Hopefully that will make it so that going forward, you guys have the tools to decide what you want to do. You don't need a bill like this. I want to thank you again for the opportunity to meet with me first thing, pre or post donut. And I'd like to turn it over to my colleague, Jeff Saling, who has been so supportive in helping us and helping Nevada try to create an entrepreneurial ecosystem and an environment for our businesses. Jeff?
Thank you, Lieutenant Governor Marshall. I really appreciate it. So I'm hoping that you guys can see the screen with the presentation on it now. Can somebody give me a thumbs up or something to let me know that's okay?
We cannot yet see it, but I think our tech folks probably can help with that.
Here we go, screen 3.
Oh,
all right,
there we go.
How about now?
Yes, we can see it. Thank you.
Great, terrific, thank you. And again, thank you, Lieutenant Governor Marshall. And for some other context about why I'm here and why I care so much about this issue and what Startup NV is and does. Startup NV began in 2017 out of a frustration that I had. I spent my career in enterprise software startups, 7 of them. 3 went through to an IPO and 1 was acquired and 1 is still in startup mode. And 2 of them failed. And I came to Nevada in 2009 in the middle of the 3rd startup and the 2nd IPO with the idea that I'd start my next company here. And when I came time to do that in 2010, I couldn't find the capital or the coders I needed. What we lacked here is what I came to understand is a startup ecosystem. So I left on planes every week to do my startup work in Seattle and Austin, Texas, where in 2016, my company was working in an incubator program there called the Capital Factory. And I loved the atmosphere and wanted to join one when I returned to do my next startup, but found that there were none in Nevada. So rather than run off again, and some colleagues and I decided that we'd pay it forward for our good career fortune, and that payment became Startup NV, a nonprofit business incubator and accelerator to help grow our startup ecosystem here. And I've learned a lot since then. We've had more than 550 companies pitch to us to get into the program. 48 of them have gotten in, with 20 of them raising over $65 million. But less than 1% of that investment came from Nevada investors. And frankly, that's not the sign of a good, healthy ecosystem. So for our startup ecosystem to be successful, we need early stage capital to come from local sources. And that's an important ingredient of what makes a startup ecosystem successful. And I think SB 9 helps solve that important issue. And that's part of the puzzle. And that's why I support it. So the graphic will set context for the entrepreneur's journey through the fundraising process and show where SB 9 will have an impact. So all startups begin with an idea and then proceed left to right through the stages noted. Outside investment usually starts with friends and family, and when the concept has to be validated, and then proceeds with larger and growing capital requirements to build a product and go to market as the company matures. The organizations, angel groups, pre-seed funds, seed funds, venture funds that provide capital for these early stage startups are the subject of the presentation today and SB 9 generally. With a vibrant community providing capital, startups hire staff, grow jobs, spend money in the local community, grow rapidly, hopefully establish a successful business, then have a successful exit by acquisition or IPO, or perhaps a SPAC, which are more popular these days. Where founders and investors and employees, they have a great payday. And after that payday, these successful folks consider retirement. They buy a few cool toys for whatever their hobbies are. But after about 90 or 120 days, they're bored. And guess what? They start another company, or they become an angel investor, or they do both. And that virtuous cycle is what we want happening here in Nevada. Without a vibrant community providing capital at these early stages, startups struggle. And very few, if any, of these things happen. So the laws and regulations in this area, as the Lieutenant Governor said, are called blue sky laws. And the current situation that we have is messy and confusing. Investors can usually handle the risks and the opacity of startup businesses. But when the laws and the regulations governing their investments are not clear or they're overly complex, investors just stay on the sidelines or they simply invest other places. So we have some confusing laws and rules in Nevada that haven't been updated in a long time. They're inconsistent or they conflict with the federal regulations that cover these same activities. And Nevada laws, for example, Nevada laws sees founders that are raising capital for their own companies as a salesperson, like they're a stockbroker and they need to hold a license. And when someone wants to raise an investment fund to make investments in startups, those rules too are murky, and the roles of the founder and the fund manager are conflated, and it's unclear when licenses are required and when they're not, meaning deals that people invest in can be litigated and unwound, and no serious financial professional fund is going to get formed under these circumstances. And none of these investors or funds are going to consider relocating here. The people in the funds might move here because they like our tax environment, but they'll invest elsewhere. Since over 80% of all the capital raised in the early stages comes from local investors who want to support their local startups, And the actual average mileage is 37 miles based on national averages. Is where the founder and the funders typically are within 37 miles of each other. It's not a good situation here in Nevada, and we consistently rank near the bottom for startups' access to early stage capital. But the good news is there's a really straightforward fix for all of this to make our laws consistent with the federal standards and keep those standards consistent over time. Investors understand and are used to complying with the federal rules. That level of clarity and consistency will remove the barriers and clear a path for local investment that drives these early stage startups. Whether the local investment is from our current citizens or those who are thinking of moving here. NASA, the model legislation that 23 other states have adopted and that's introduced in SB 9 makes Nevada consistent with federal laws. What happens if we follow this path? Investment in our local stage startups increase. From the sort of paltry total of $2 to $5 million, which is what we have now, to probably 5 times that or more. And if you follow some of the models generated by software programs like Implan, and we got a look at our models courtesy of the city of Las Vegas. They let us use their Implan software to model some of this stuff. Generally, every dollar of private investment generates about $20 of economic activity. And that means we generate hundreds of millions of dollars in new economic activity and start to see the diversification of our economy with, from all of these high growth startups, this diversification that we've all been talking about for many years. And that's without taking anything away from the existing awesome industries that are already here. This SB 9 fix helps earlier stage, smaller local funds get started and attracts and incents formation of the larger, later stage funds that follow on, because the laws are clear and the earlier funding has created exciting options for those larger funds to consider. So in summary, the NASA fix, SB 9, puts us on par with other states and with federal regulations. This clarity and consistency will remove barriers to the capital growth and making early stage investments in a manner everyone in the investment community is already used to operating under. There's no new learning or other barriers to getting started. And from there, we can see the more rapid local capital creation in Nevada, investment in early stage startups and job growth that we all want. This will have the biggest impacts in Las Vegas and the rural areas where there are literally none local startup funds happening right now. And it's also going to help with the North to form new funds and attract new funds from externally as well. And as a final note, and it's certainly not the least important note, more capital options and ease of regulations will make it easier to create funds to invest in the underserved communities. Specialty funds for female founders, Black founders, Hispanic founders, veteran founders, which helps provide the needed early stage access to capital for all Nevadans. So there's many organizations from across the state that are supporting this work, and their letters of support were submitted originally to the Senate side under SB 9. And I want to thank again Lieutenant Governor for raising this important issue. I think it's a well-crafted solution for your consideration. And Assembly persons, thank you for your consideration for the bill and for listening to my testimony and for your time.
Thank you so much, Lieutenant Governor, Mr. Saling. Appreciate the presentation. Just want to confirm, Lieutenant Governor, is that it for the presentation? Are you ready for questions?
Kate Marshall for the record. Yes, Chair.
Thank you so much. And just so the record's clear, I haven't yet had a donut today, but there are a lot of hours left in the day, so we'll see if we can make that happen. Do we have any questions for our presenters on Senate Bill 9 as it was presented? Well, I'm going to ask one, and we'll give folks a chance if there are additional questions. And I think, Mr. Saling, it's probably for you. And, although it's not necessarily touched upon directly in Senate Bill 9, I was just curious to get your take on what the standards are for individuals making investments in some of the funds or the investments you mentioned. I'm particularly interested in friends and family members. Are they able, under our current laws, to invest in things like that? Or what is your view on what our state laws say in that regard? Well,
the current situation with the state laws is confusing. the federal laws very tightly define who can invest in early stage startups. They're called accredited investors on the federal standard. From the state standards, it's vague as to whether or not somebody who's not an accredited investor can actually make an investment in their own family's business. Usually those kinds of things are not pursued by regulators. But if the family relationship gets a little rocky, that's when you see the lawsuits and other things start to happen. It would be better, I think, if we were to make it absolutely clear, either by federal standards or some other clear standard of our own, that would make it clear who could and couldn't invest.
Thank you, Mr. Saling. Appreciate that response. Committee members, any additional questions? Assemblyman Wheeler, please go ahead.
Thank you, Mr. Chairman. Mr. Saling, as an angel investor, what is the benefit for me for you to pass this law? Is there a tax benefit? Is there a fee benefit? What is the benefit for me in plain, simple English?
Jeff Saling, for the record. Sorry, I didn't say that the last time. When you say for you, Assemblyman, do you mean you personally, or you as a member of the Assembly?
No, I mean as an angel investor. Okay. What is the benefit for me that I don't have now if we pass this law?
Well, you'd be if you pass this law, you would have certainty if you were investing in the Nevada business that you were complying with the law as it's stated right now federally, meaning if you obeyed all of the federal regulation with regard to being an accredited investor, that you would be certain that your investment would be legal, that it would be within the standard of the law. And that's really that simple, that you would know that when you made the investment, if for whatever reason a regulator wanted to investigate that investment, that it would be a legal transaction and couldn't be unwound and would likely not survive any kind of litigation because you said, hey, I wasn't accredited, or I didn't know what I was doing.
Okay, thank you. The follow-up, Mr. Chair?
Please go ahead.
Just real quick. What you're saying is right now, if I were to invest in my son's new business as an angel investor, that actually might be illegal.
It might be, yes.
Okay.
And that was Mr. Saling, for the record. I'll try to remind you to do that. I know it's not a natural thing to do, so you're not the first one who's failed to do it this session. You won't be the last. Committee members, any further questions for our presenters on Senate Bill 9? Assemblyman O'Neill, I can't tell if you have your hand up or not. It looks like he does. Please go ahead, Assemblyman O'Neill.
Thank you, Chair. I was hesitating slightly, but I was going to ask Madam Lieutenant Governor if she could just go over one more time. She went fairly quickly concerning the 2/3 requirement. As I understand, there's a reduction in fees, but that's made up, and that's the part where I lost as I was trying to follow some of her in the bill itself, her statements.
Thank you, Assemblyman O'Neill. Kate Marshall, for the record, through you, Chair Yeager, through to Assemblyman Neal. Thank you very much for the question, because I think it's an important one. So the Secretary of State told us that they tried to estimate if there would be a loss in licensing fees due to the passage of this bill. They estimate that those licensing fees would be approximately $12,375 per year. In an effort to give them an opportunity or the flexibility, if they do indeed see that loss in revenue, to bring it back up to neutral, we have in the bill that they may, if they choose, enact a fee to make up for those loss of revenues. They don't have to enact a fee. At this point, we don't know if there will be a loss of revenues, how much the loss of revenues will be, if it will be more or less. But I think the Secretary of State's office has the expertise in that area, so I'm going to use their numbers. So assuming that they do have that loss in revenue as they anticipate, they could come forward with a fee so that they could, this would be revenue neutral for the Secretary of State's office. So it is not a requirement that the Secretary of State office set a fee, but they may if they so choose, which we thought was appropriate because if there is a loss of revenue, we think it is appropriate that this be a revenue neutral bill in that regard. But the 2/3 requirement then comes to answer your question, taking way too long to answer your question. The 2/3 requirement comes from the fact that there is the possibility that they could enact a fee.
Chair, if I may, one short follow-up, hopefully.
Please go ahead.
Madam Lieutenant Governor, I was reading this. That's what sort of bothers me now is the may part. Is there any way, or can we look at that they first must show to the legislature the loss before they can go forward with the fee? Do you think?
Thank you, Assemblyman Neal, through you, Chair Yeager, to Assemblyman Neal. That is a great idea. Because we are working with the Secretary of State's office on trying to make sure this is revenue neutral, I would entertain any language like that. Actually, that's a great idea. Did you have some wording, or may I get back to you after talking with the Secretary of State's office? How would you like me to proceed, sir?
Madam Lieutenant Governor, I just thought of it just now, so I'm not that sharp, I guess. But what I was thinking about is with your report that's in there that I really do like that report. Maybe we wait until after the report they can show and then look at it to the next legislature if there's a fee necessary, a fee hike to allow them to do that fee. Possibly something on that lines, but I'd love to hear back from you and work with you on tightening that up some. But I think we could do it in 4.5. I think.
Thank you, Assemblyman Neal. Kate Marshall for the record, through you, Chair Yeager, to Assemblyman Neal. Thank you very much. And we have also been working with Assemblyman Chair Yeager. And also the amendment was written by a securities professor at UNLV who has been very helpful. So let me try to gather greater minds and see if we can't come up with that. And let me check in. I need to check in with the Secretary of State's office because with respect to the amendment, obviously we talked to them first. So let me check in with them. And I will get back to you as soon as I can, if that's okay with you, sir. And if that's okay with you, Chairman Yeager.
Thank you very much for the willingness to work with us. I truly do appreciate it. And thank you for the time, Chair.
You're welcome, Assemblyman O'Neill. I think we have a question next from Assemblywoman Summers Armstrong.
Thank you, Chair Yeager and Ms. Marshall. I appreciate the presentation. I just have trying to understand. So investments for angels would still be run through an authorized investment professional who would advise people of all the risk of their investments, and you all are just trying to make this match with the rules that are presently in place. I saw in the digest of Dodd-Frank federal rules. Is that what I'm understanding? Just to make things clear from our state and comply with the federal rules.
Yes, thank you, Assemblywoman, and through you, Chair Yeager, to the Assemblywoman. I appreciate the question, and it's an important one. But because I want to make sure that we are accurate, I want to turn this over to Jeff Sailing, if that's okay with you, Chair Yeager, because he is more familiar with the exacting prescriptions of the rules.
Yeah, that would be fine. And Lieutenant Governor, you don't have to go through me when you're answering questions unless you'd like to do that, but feel free to go directly to the member.
Kate Marshall, for the record, pre-donut, I do whatever is needed. So
That's a fair point. And Mr. Sailing, if you could answer that question, please.
Thank you, Chair Yeager, Jeff Sailing, for the record. And Assemblywoman, great question. This is a really straightforward bill. As you suggested, it aligns us perfectly with the current federal law. It doesn't make us different. It aligns us exactly with that law. So we will follow the rules that are federally out there right now. Unless people decide they're going to amend this bill and change it in some way, that right now as it stands, it would follow the rule exactly as it is federal.
Okay, do we have additional questions from committee members? I think everyone's on one screen this morning, so I can see you all. Okay, I don't see additional questions. So again, want to thank our presenters. We'll ask you to sit tight for just a moment. We'll see if there's any testimony on the bill, and then we'll come back to you for a chance to wrap up. I don't believe we have anyone on the Zoom with us who is here to testify on this bill. BPS, could we go to the phone lines to see if there's anybody there who would like to testify in support of Senate Bill 9?
Good morning. Thank you, Chair. For callers wishing to provide testimony in support of Senate Bill 9, please press star 9 now to take your place in the queue. And we will begin with caller with the last 3 digits of 131. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good morning, Chair Yeager and members of the Assembly Judiciary Committee. My name is Connor Kane, ConnorCain, and I'm testifying on behalf of LVGEA in support of Senate Bill 9. LVGEA believes this bill will help bolster the growth of startups in Southern Nevada and encourages your support. Thank you.
Thank you for your testimony, Mr. Kane. BPS, do we have additional callers in support?
For callers wishing to provide testimony in support of Senate Bill 9, please press star 9 now to take your place in the queue. And Chair, there are no further callers in support at this time.
Thank you, BPS. I'll close testimony in support. I will now open it for testimony in opposition. We don't have anyone on the Zoom in opposition. BPS, could we check the phone lines to see if there's somebody there?
Thank you. For callers wishing to provide testimony in opposition of Senate Bill 9, please press star 9 now to take your place in the queue. For callers wishing to provide testimony in opposition of Senate Bill 9, please press star 9 now to take your place in the queue. Chair, there are no callers in opposition at this time.
Thank you, BPS. I will close testimony in opposition. I will now open it for testimony in the neutral position. We don't have anyone on the Zoom in neutral. BPS, do we have anyone on the phone?
Yes, thank you, Chair. For callers wishing to provide testimony in neutral, please press star 9 now to take your place in the queue. And Chair, the public line is open and working. However, there are no callers in neutral at this time.
Thank you, BPS. Appreciate that. I'll close neutral testimony and we'll now go back to our 2 presenters, Lieutenant Governor and Mr. Sailing, for any concluding remarks on Senate Bill 9.
This is Lieutenant Governor Kate Marshall for the record. Again, thank you for having me this morning. I greatly appreciate it. We will get back to you on Assemblyman O'Neill's ideas and see what we might be able to do to accommodate those. And I really appreciate coming forward with the idea. Thank you very much.
Thank you, Lieutenant Governor. Mr. Sailing, any concluding remarks?
Jeff Sailing for the record. Thank you, Lieutenant Governor, for bringing this issue forward. And thank you, Assembly people, for for hearing the testimony and for considering this bill. Thanks.
Great. Thank you so much. Thanks for joining us here, spending some time with us on your Wednesday morning in Assembly Judiciary. We greatly appreciate it, and we'll be in touch about some of the ideas that were brought up in today's hearing, and look forward to working with you on that. So thanks again, and please have a great rest of the day. Okay, I'll now close the hearing on Senate Bill 9. Committee, that means we're moving right along on our agenda. Again, we are going to take the bills in order. So at this time, I'm going to open the hearing on Senate Bill 31. Senate Bill 31 makes various changes relating to public safety. And I believe we have Ms. McKay with us on the Zoom to hopefully present the bill. And then I'm sure we'll have some questions for you. So welcome, Ms. McKay, to the Assembly Judiciary Committee, and please proceed.
Thank you. Good morning, Chair Yeager and members of the committee. For the record, I'm Erica Suzuyamas, and I'm the Records Bureau Chief with the Department.
I'm sorry about that. The name on the computer says McKay, and I was looking at the screen. I said, that doesn't look like Miss McKay, but welcome to the committee, and sorry for getting your name wrong there.
That's okay. Thank you. We threw you for a loop today. For the record, I'm Erica Suzuyamas, and I'm the Records Bureau Chief with the Department of Public Safety Records Communications and Compliance Division. I'm here today to introduce Senate Bill 31. The Records Communications and Compliance Division houses the central repository for Nevada records of criminal history pursuant to NRS 179A-075, which maintains statewide records of Nevada arrests and dispositions and is also responsible for administering the state's Uniform Crime Reporting Program and conducting name-based background checks pursuant to NRS 179A-103. Section 1 of this bill amends the definition of a record of criminal history under NRS 179A.070 by replacing the word district attorney with prosecuting attorney to ensure that the central repository receives charging decisions from all prosecuting offices across the state, which will include not only district attorneys, but city attorneys, as well as the Office of the Attorney General. This will ensure we receive all information pertaining to a criminal arrest to meet our mission of having complete and accurate criminal history records. Complete and accurate criminal history records are critical to making multiple civil and criminal determinations, such as employment, licensing, firearms transfers, charging, and court decisions. Section 2 of this bill pertains to the division's Uniform Crime Reporting Program, which we refer to as UCR. Section 2 amends subsection 8G of NRS 179A.075. Currently, this section requires the division to prepare and post on the Central Repository's public website an annual report containing statistical data relating to crime. The amendment proposes to provide an electronic means to access the data on the Central Repository's public website. Currently, repository staff spend months preparing the annual report for publication. The repository has recently implemented an electronic UCR repository where the crime statistics will be maintained on the division's public website. This website allows any member of the public to search for any particular data relating to crime for which the central repository collects. Information on the website will be available more timely rather than only once a year with the current annual publication, and will be accessible as soon as the local law enforcement agencies enter their respective data into the statewide system. This will eliminate the need for repository staff to spend months each year preparing the manual report and will allow more timely access for the public, thus making the Uniform Crime Reporting Program more efficient. Furthermore, Section 2 amends subsection 8H of NRS 179A.075 to provide for the same mechanism of data access as I just described, which pertain to statistical data regarding domestic violence in this state. Section 3 of Senate Bill 31 relates to our civil name check program, which is a name-based background check service that we offer pursuant to NRS 179A.103. This amendment removes subsections 5A and B of that NRS and is a proposed remedy to authorize a division to continue with our current processes. Repealing 5A will allow the authorized participants to receive a full criminal history record to afford them the information needed to make a final determination. This is consistent with our fingerprint-based background checks, whereas we provide the full criminal history record. Our program offers a research service which allows the authorized participants to request that our staff conduct further research on a record to attempt to obtain additional information to make an informed final determination. Repealing 5B removes the requirement of the central repository to provide information which pertains to an incident for which an employee, prospective employee, volunteer, or prospective volunteer is currently within the system of criminal justice, including parole and probation. As a result of a Supreme Court ruling issued in March of 2020, the department's legal counsel advised that the central repository was not authorized to disseminate parole and probation's information under NRS 213.1075. Going back to UCR, Section 4 of this bill amends subsection 8A of NRS 179A.350, similarly to the amendments sought in Section 2. Currently, the Central Repository compiles an annual written report concerning various temporary and extended orders for protection and provides the report to the Director of the Legislative Council Bureau on or before July 1st of each year. As with Section 2 of this bill, these amendments provide for the same mechanism of data access. The data pursuant to this section will be placed on the division's public website, whereas the Director of the Legislative Council Bureau may access the information at his or her leisure. And finally, Section 5 mirrors Section 4 of this bill. However, the report pertains to statistical data on the abuse, neglect, exploitation, isolation, or abandonment of older persons or vulnerable persons. Currently, the Central Repository compiles an annual written report concerning statistical data for the aforementioned vulnerable population and provides the report to the Director of the Legislative Council Bureau on or before July 1st of each year. As with Sections 2 and 4 of this bill, these amendments provide for the same mechanism of data access. The data pursuant to this section will be placed on the division's website, whereas the Director of the Legislative Council Bureau may access the information at his or her leisure. This concludes my presentation, and with that, I request the committee's support for Senate Bill 31, and I'm happy to answer any questions that the committee may have. I'd also like to add that we'd be more than happy to meet with any of you separately to discuss any of our programs to provide additional information. Thank you.
Thank you for your presentation, Ms. Souza Llamas. Before I take questions from the committee, I just wanted to confirm, when you were describing the bill, you were referencing amendments, but I think you were referencing that the NRS is being amended. There aren't any proposed amendments for the actual bill, are there?
No.
Okay,
Erica Souza Llamas, for the record. No, there's not.
Thank you. I thought that was the case, but just wanted to make it clear for the record. We do have some questions from committee members. I'll start first with Vice Chair Nguyen.
Thank you, and thank you for the presentation. I will tell you, I don't really have a whole lot of problems with the bill, although I have like a huge problem with Section 3. I know that in 2017, we passed out of here legislation. It was the late Assemblyman Tyrone Thompson's bill that was kind of the ban the box legislation that, changed it from a situation where employers would get convictions. But it appears that in Section 3, we are going back on that, like what I think is very good policy. And now we are giving employers all of the arrest information, including unsubstantiated like arrests that are a part of like the entire criminal history. I mean, is that the intent? Like, why are we rolling back some of those ban the box like type legislation that we passed in 2017?
Erica Souza Llamas, for the record. Thank you for the question. Senate Bill 31 does not change the intent or doesn't undo anything that was passed in AB 384 in 2017. Multiple statutes were enacted under AB 384 in the 2017 session. The same information is going to be provided as has always been provided in our civil name check program. I believe 384, the language in there pertains to state or local government agencies and doesn't allow them to consider the criminal history background of an applicant or other qualified person prior to the earliest of either a final interview conducted in person or the appointing authority has made a conditional offer of employment to the applicant. So Senate Bill 31 doesn't impact what was enacted under AB 384 in 2017.
Chair, may I follow up?
Please go ahead.
So when you're like in that section 5, section 3, subsection 5, it talks about how it would be pertaining to records of criminal history. What is included in that criminal history, like distribution? Like what is given to someone if they, if the central repository is disseminating an authorized participant of that service? What is included in that criminal history?
Erica Suziyamas for the record. Our criminal history records contain arrest information. So when a subject is arrested, we get their arrest fingerprints. The arrest information is there. We have prosecution information and court information if we've received all of that from the courts as well.
So unsubstantiated or just arrests or citations would be included on those criminal histories that were given to people if they were requesting them through this central repository. Is that correct?
Erica Suziyamas for the record. Our records of criminal history do not contain citations.
Okay, but any kind of criminal arrest, even if it's later substantiated or denied or the person is found not guilty, would still be included on that criminal history.
Erica Suziyamas, yes, it would.
Thank you.
Do I have other questions from committee members? Assemblywoman Cohen, please go ahead.
Thank you, Chair. Sorry, I have too many windows open. I have a question in section 2 sub 8D3, which is on page 6, line 34. It's existing language, but it's reference to moral turpitude, crimes of moral turpitude. And I know over the last few years, there was an effort to take moral turpitude out of the term out of our statutes, led by former Senator Parks. But can you tell me what that's referring to in this bill, or I mean in this section of the statute, and if you'd be adverse if we remove that language?
Erica Suziyamas for the record. Quite honestly, I'm not sure what the definition of crimes of moral turpitude include. As far as removing that language in the bill, I don't see any issues with that if that were to be proposed.
Thank you. And Chair, could we have Council maybe address that for us, or if not now, maybe look into that and let the committee know as we proceed with this bill, because certainly it's a good opportunity to possibly take out that dated and somewhat coded language, let's say.
Thank you, Assemblywoman Cohen. Mr. Wilkinson, not to put you on the spot, but want to give you a chance to respond to that if you have a thought right now, or if not, just let me know you need a little more time and we can have you follow up afterwards.
Thank you, Mr. Chairman. I'd be happy to look into that issue some more. There's a lot of, well, maybe there's not a lot. There's some case law from other states about what a crime of moral turpitude is. It's kind of a complicated issue and something we would need to look into a little more, if depending on what the desire of the committee is to do with that section. Simply removing it obviously would be easy enough, but if there's some desire to define it in some way, that's probably going to take some work.
Thank you, Chair, and thank you, Mr. Wilkinson, and thank you, Ms. Suziyamas, and I realize I'm putting you on the spot as well, and if maybe you can just look into that with your department to make sure if we did choose to do something, the committee that is, that would be acceptable to your office.
Absolutely, Erica Suziyamas for the record. We're happy to work with council on that.
Thank you. Do we have additional questions from committee members? Assemblyman O'Neill, please go ahead.
Thank you, Chair. Ms. Suziyamas, I just want to make sure I see the effectiveness date is upon passage and approval on NIBRS. Will this make us a NIBRS compliant state And two, are all the agencies that contribute, are they capable of putting into the electronic data form, or is it still going to be a hand tabulation or submission, I should say?
Erica Suzuyamas for the record. Thank you for the question. Nevada is already a NIBRS compliant state, so we became compliant effective January 1st of this year. All of our contributing agencies to the UCR program are currently submitting through an electronic means, either directly into NIBRS or through one of the tools that we've implemented for them if they haven't been able to, if they don't have their own local case management systems that are interfaced with the NIBRS program.
Excellent. I look forward, because it's a great program. And thank you. And thank you for the time, Chair.
You're welcome. Do we have additional questions from committee members? If you have a question, if you could raise your hand, please. Okay, I don't see additional questions at this time. So Ms. Suzuyamas, thank you for presenting. We'll ask you to sit tight for just a moment while we take some testimony on the bill, and then we'll have a chance for concluding remarks. I don't see anyone, sorry, I'm going to open up testimony in support. I don't see anyone on the Zoom who is in support. BPS, could we go to the phone lines to see if there's anybody there in support?
Thank you, Chair. For callers wishing to provide testimony in support of Senate Bill 31, please press *9 now to take your place in the queue. And Chair, there are no callers in support at this time.
Thank you, BPS. I will close testimony in support. I will now open testimony in opposition. We don't have anyone on the Zoom in opposition. BPS, could we go to the phone lines to see if there's anybody there in opposition?
Thank you. For callers wishing to provide testimony in opposition of Senate Bill 31, please press *9 now to take your place in the queue. And we will begin with caller with the last 3 digits of 080. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Hi, Jim Hoffman, representing Nevada Attorneys for Criminal Justice. NACJ wants to thank the proponents of the bill for bringing it. We don't oppose most of it, but we do oppose Section 3 based on the concerns that Assemblywoman Wynn raised. Specifically, we oppose it because it would expand background checks to cover arrests and other information. I'd like to share an anecdote that illustrates why this is a harmful idea. I had an African-American client once who was stopped by the police more than 50 times and arrested more than 20. Only 3 of those arrests led to prosecutors filing charges, all of which led to convictions. Twice for not having a business license, and once for possession of marijuana before that was legal. None of the other stops or arrests led to a conviction or even to charges because he wasn't doing anything wrong in any of those cases. That's not just my opinion. That's the opinion of the prosecutors who declined to file charges. Now think about what would happen to my former client if SB 31 passes. Anytime he applies for a job or an apartment, the background check is going to show 20-something arrests. No employer is going to ask him what the context of that is, and few, if any, are going to stop and parse the difference between arrests and convictions. They're just going to look at that multi-page arrest printout, assume he's some kind of hardcore career criminal, and reject him out of hand. This former client of mine is an unusual case, but he's not the only person in this position, and many other people have less severe versions of this problem. SB 31 would not improve public safety. It would just place an unnecessary burden on the ability of people to get jobs and housing. Therefore, NACJ opposes it. Thank you.
Thank you for your testimony, Mr. Hoffman. BPS, could we go to the next caller in opposition, please?
Yes, next caller with the last 3 digits of 611. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good morning, Chairman Yeager and members of the Assembly Judiciary Committee. This is John Piro, John-Piro, from the Clark County Public Defender's Office, and my opposition is also focused on Section 3, subsection 5A. Currently existing law, NRS 179A.103, means that the central repository shall disseminate only convictions. And And I have to imagine that this body considered that when originally crafting NRS 179A.103, just like Mr. Hoffman said. And then to hear that the Central Repository has maybe been giving this information out anyways, if so, have they been violating the law, and for how long? If they've been giving this information out, and that's the way they've always been doing it. So that is a little bit concerning to us. We have the same issues that Mr. Hoffman expressed right before us, so we oppose removing Section 3, subsection 5A, to give unsubstantiated arrest to employers and make it harder to get a job. The surest cure for recidivism is a good job, and this bill would go against that. So it may not directly violate the words of Tyrone Thompson's Ban the Box legislation, AB 384 from 2017, but it definitely goes against the intent of that bill of letting people get a fair shot at employment. So for that reason, we oppose. Thank you.
Thank you for your testimony, Mr. Pirro. BPS, could we go to the next caller in opposition, please?
Thank you. Next caller with the last three digits of 318, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good morning, Chair Yeager and members of the committee. This is Kendra Birchie, BERTSCHY with the Washoe County Public Defender's Office. I do want to thank the Department of Public Safety for meeting with us prior to the bill hearing in the Senate to address our concerns. I would echo the statements made by Mr. Hoffman as well as Mr. Pirro, and that my office's concerns is also with Section 3 and just with Section 3. It's our understanding that the purpose of this bill regarding this section is due to fiscal issues where the department's unable to then just provide the records which reflect criminal convictions only. And unfortunately, although we understand the fiscal issues and the time constraints and all the issues that we put on the Central Repository, this is a very important issue because employment is the key to reducing recidivism. So the more ways that we are decreasing a person's ability to get a job, we believe that that is unfortunately impacting our public safety. So we do oppose this bill specifically with Section 3 and agree that it unfortunately does not comply with the intent of Assemblyman Tyrone Thompson's bill, which was to get rid of the stigma, to allow for the prospective employers to get to know the prospective employee for their values and for their work ethic, their education, and for their experience rather than their involvement in the criminal justice system. Thank you for your time and attention.
Thank you for your testimony, Ms. Birchie. BPS, are there additional callers in opposition?
Chair, there are no further callers in opposition at this time.
Thank you, BPS. I will close opposition testimony. I will now open it for neutral testimony. We don't have anyone on the Zoom in neutral. BPS, do we have anyone on the phone lines who'd like to offer neutral testimony?
For callers wishing to provide testimony in neutral on Senate Bill 31, please press *9 now to take your place in the queue. Chair, the public line is open and working. However, there are no callers for neutral at this time.
Thank you, BPS. I will close neutral testimony. Ms. Suzayamas, if you'd like to make any concluding remarks, this would be the time to do that. So please go ahead.
Thank you, Erica Suzayamas. I don't have anything further to say. I just want to say thank you to the committee for your time this morning. And we're here to answer any questions if you have any.
Great. Thank you so much for the presentation. Appreciate you being here. Thanks for spending a little bit of time with us on Wednesday morning, and we hope you have a great rest of your day. So I will now close the hearing on Senate Bill 31. Moving right along, that takes us to the final bill listed on the agenda. I will open the hearing on Senate Bill 42. Senate Bill 42 revises provisions relating to certain court rules and decisions. We have Mr. McCormick with us here on the Zoom to present. Welcome to Assembly Judiciary, Mr. McCormick, and please go ahead.
Thank you, Mr. Chair. For the record, my name is John McCormick. I'm the Assistant Court Administrator at the Nevada Supreme Court's Administrative Office of the Courts. Senate Bill 42 is intended to transfer the responsibility for printing and distribution of Nevada reports, advance opinions, and court rules from the Legislative Council Bureau to the Supreme Court. That responsibility used to lie with the Secretary of State's office prior to 1973. And then in 1973, LCB took over that responsibility. At this point, it seems appropriate for the court to take over that responsibility of disseminating its own sort of decisions and rules. This bill also eliminates the statutory requirement to print 750 hard copies of Nevada reports, and those are the collected opinions of the Supreme Court, and rather gives discretion on how many hard copies to print to the Chief Justice. Currently, we end up with a bunch of extra hard copies of Nevada reports that nobody wants, that we keep in storage with state printing and LCB. So this would attempt to address that. For this fiscal year, it costs about $28,832 to print those hard copies that end up going in total, and some of those go unused. So this would potentially result in a little bit of a cost saving there. I know this isn't a money committee, but feel compelled to share that. This bill allows distribution printing in paper and electronic format in order to modernize that dissemination and also to let us meet the needs of recipients. There are a number of entities that receive this information by statute at no cost, and some want to receive it electronically. So this will explicitly allow that to modernize that distribution. Practically, we don't really have any plans to change from utilizing state printing. And I've had a conversation with Ms. Erdos, the director of LCB, and we're all committed to continuing to share this information freely with LCB for inclusion in publications, etc. And the idea is to create more access to the court's opinions than currently exists. As I indicated, people who currently receive free sets under statute will still get a free set, and obviously that will be provided to the Legislative Counsel Bureau as well. I would just note that this is not intended as a money-making endeavor. The amount of revenue that's brought in from sale of Nevada reports is fairly minimal. However, this does transfer that money from the Legislative Counsel Bureau to the Supreme Court to help offset those printing costs. This bill also removes the statutory requirement that the Supreme Court require by court rule training regarding medical malpractice cases to district judges. That requirement was added in during the 2005 special session when the state was experiencing what was referred to as a medical malpractice insurance crisis. However, at this point, medical and professional liability education for district judges is a core competency under our district court judge training model and is regularly trained, usually every 2 to 3 years. We train on this, we train about medical malpractice to our district court judges last year during our what became a virtual district court judges seminar, and we'll continue to train that as appropriate and necessary. We've also seen increased specialization within the district courts, which has allowed judges to become experts in or gain more expertise in specific issue areas, including medical malpractice. So we think that the statutory requirement for that training is no longer necessary, as it's part of our core competency training scheme, and we do have that specialization. That is basically what Senate Bill 42 does. I can go section by section if people would like that, or I stand ready for questions.
Thank you, Mr. McCormick. Appreciate your presentation. Why don't we see if folks have questions, and that can help guide the discussion from here on out. Members, are there any questions for Mr. McCormick on Senate Bill 42? Which is a little different. This bill is a little different than some of the ones we've been hearing. It's kind of nice to get a bill about printing versus some of the topics we've been taking up the last few weeks. So committee, one last call for, go ahead, Assemblywoman Bilbray Axelrod.
Thank you. And this is new to me. So I guess I just want to be able to clarify what is available to folks online. So if the hard copies aren't there, is there another avenue that they can find out? And is this information, are decisions typically always made available, or is there sometimes where things are redacted? Or Just trying to wrap my mind.
Thank you, Assemblywoman. For the record, John McCormick. Yes, this information is available online. All advance opinions are available on the Supreme Court website, and this actually will increase the availability by allowing us to publish it electronically. Decisions, court rules, etc., are also available through a number of other sources, like Westlaw, LexisNexis services, and also as we'll continue maintaining our relationship with LCB and disseminating this information, it will continue to be available on the legislature's website where you can find a lot of this right now. So we're hoping that this actually increases the availability of that information. As I said, the hard copies are sort of old school, and a lot of people now want it electronically rather than in hard copy. Anecdotally, a number of attorneys say, "What, hard copy? I always use the online version." So that's our intent, is actually to make it more available. And again, advance opinions are published on the Supreme Court's website. If you go to our website, you can find them right on the front page.
Quick follow-up, Chair.
Yes.
And just to make it abundantly clear, there's nothing that would limit them pulling up the copy on the internet and then printing it, correct?
Thank you, Assemblywoman. For the record, again, John McCormick. No, if it's on the website, you can print it. The only restrictions would be through those other services like LexisNexis and Westlaw that folks pay for. But if you just sort of went to it through the normal channels, yeah, you can print to your heart's content.
Thank you.
Okay, do we have additional questions? I thought I saw a couple more hands. Assemblywoman Summers Armstrong, did you want to ask a question?
Thank you, Chair Yeager. And thank you, Mr. McCormick, for your presentation. If you're not going to be teaching Med-Mal as regularly, are you going to address training for the other specialty courts that you mentioned earlier, or is that training only for those who work those specialty courts, or is that broad training for all judges to deal with those issues in some of the specialty courts, the veterans courts, the drug courts? If you can elaborate. Thank you.
Thank you, Assemblywoman. For the record, again, John McCormick. Medical malpractice, as I said, is a core competency for all our district judge training. So all district judges have the opportunity to receive that training. As far as specialty court training, we every other year hold a specialty court conference for all Nevada specialty courts. This past year, 2020, we had our first virtual conference. We had over 252 unique attendees at that. We also sponsor specialty court teams to go to the National Association of Drug Court Professionals Conference, which is the premier training event for specialty courts. We, in the past, have brought tune-up training from the NADCP and the Drug Court Institute to Nevada. We also fund, through our specialty court funding, training for individual team members. So this medical malpractice requirement isn't necessarily connected to our specialty court training, which is pretty robust. We also train at our judges' seminars on substance abuse, mental health type issues at both the district and limited jurisdiction level. For example, we just produced a webinar. It had a family court focus, but was available to all judges regarding opioid addiction and how that the interplay of that in terms of family courts. And the state bar has also mandated that all attorneys receive training on substance abuse within the legal profession. And so we also make that training available to our judges so they can fulfill those CLE requirements. So that training is usually oriented, like as I said, to substance abuse within the profession. But I think we have a fairly robust training program across all those areas.
Thank you.
And of course, we have I don't know if you mentioned it, Mr. McCormick, but we have the National Judicial College right up here in Northern Nevada, up in Reno. And that's mandatory for all newly elected judges. Then I think there are refresher courses as well. But I would recommend to committee members, if you haven't had a chance to visit there, you should. It's a really a wonderful training ground for judges, not just from Nevada, but all across the country and internationally as well. So very proud to have that right here in Northern Nevada.
If I may, Mr. Chair, again, John McCormick for the record, just to hit on that National Judicial College point, as you indicated, all judges, when they're newly elected, are statutorily required to receive training from the Judicial College related to their specific jurisdiction level. So if it's a district court judge, general jurisdiction, family court, they have an additional family class. And sometimes that comes from the National Council of Family and Juvenile Court Judges, which is another great resource that we have in state. And limited jurisdiction judges also obviously take a course, and there's different courses because, as you know, we have some lay judges in Nevada versus attorney judges at the limited jurisdiction level. Also, all judges have to take a class regarding managing their courtroom, ethics, those kind of things. And just incidentally, that includes training on bias and those type of issues. So yeah, the National Judicial College is a valuable resource, and it's a great resource to have here in Nevada. And if I can take one more just kind of point here, just like to indicate that we're also launching a training. It's called the Red Door Project. It's out of Portland, Oregon. It deals with implicit bias, racial equality issues in the criminal justice system. We're making that available to all the district court judges in May and all of our limited jurisdiction judges in June.
Thank you, Mr. McCormick. Appreciate that. I think we have a question from Assemblywoman Cohen. Please go ahead.
Thank you, Chair. And thank you, Mr. McCormick. And I'm sorry if you touched on this in your presentation. I was IMing with counsel about something else. But in section 8, sub 5, the deletion of Supreme Court and district court rules from the NRS, can you address that and say where those are going to be and what the purpose is for that part of the bill?
Thank you, Assemblywoman. Again, John McCormick for the record. That's being removed for consistency since the publication responsibility is being transferred from LCB to the Supreme Court. They'll be available on the court's website, and we also intend to continue sharing those with LCB. So the idea is no one will actually see a difference. It's just who publishes them statutorily. So hopefully that's a behind the scenes change that nobody notices.
Okay.
And as I indicated, I talked with Ms. Erdos, and we're all on the same page in terms of keeping the pages going.
Okay, thank you. I did hear you say that, and I think I just didn't make that connection. But okay, thank you very much.
Further questions from committee members? Right, not seeing further questions. Thank you, Mr. McCormick. We'll have you sit tight for a moment. Let's see if there's any testimony on the bill. At this time, I'll open up for testimony in support. We don't have anyone on the Zoom. BPS, is there anyone on the phone line who'd like to offer supportive testimony?
Thank you, Chair. For callers wishing to provide testimony in support of Senate Bill 42, please press *9 now to take your place in the queue. Chair, there are no callers in support at this time.
Thank you, BPS. I will close testimony in support. I will now open it up for testimony in opposition. We don't have anyone on the Zoom in opposition. BPS, is there anyone on the phone?
For callers wishing to provide testimony in opposition of Senate Bill 42, please press *9 now to take your place in the queue. Chair, we do not have any callers in opposition.
Thank you, BPS. I will close opposition testimony. I will open it up for neutral testimony. There's nobody on the Zoom. I'm pretty sure there's nobody on the phone in neutral, but BPS, could you please confirm that?
Yes, Chair. For callers wishing to testify in neutral of Senate Bill 42, please press *9 now to take your place in the queue. And Chair, the public line is open and working. However, there are no callers in neutral at this time.
Thank you, BPS. I will close neutral testimony. Mr. McCormick, any concluding remarks you'd like to make? I think you were muted there, Mr. McCormick. We didn't hear what you said.
Oh. I apologize, Mr. Chair. Again, John McCormick for the record. Just thank you for the hearing, and glad I could bring you a nice, boring bill.
Thank you, Mr. McCormick. I was going to say the bill was a simple bill or easy bill, but I didn't want to jinx it. So I think we got through it only because I didn't say that. If I had said that, we probably would have had 25 people on the phone calling about the bill. So thanks for being here, Mr. McCormick. It was good to see you, and please have a great rest of the day. So committee, I'll close the hearing on Senate Bill 42. That takes us to public comment. Just by way of reminder, we reserve up to 30 minutes for public comment at the end of each meeting. Callers on the public comment line will have 2 minutes to provide public comment. Public comment is a time to raise matters of a general nature within the jurisdiction of the Assembly Judiciary Committee. BPS, could we go to the phone lines and see if there's anybody there for public comment?
Thank you, Chair. For callers wishing to provide public comment, please press *9 now to take your place in the queue. And we will begin with caller with the last 3 digits of 556. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Anne Marie Grant, ANNEMARIE sister of Thomas Purdy, who was murdered by Reno police, hogtied for 40 minutes during a mental health crisis, and then asphyxiated to death by Washoe County deputies. I call for the living because I want things to change so no family has to know the heartache that my family and so many other families know. Today I want to talk about Rex Vance Wilson. Rex Vance Wilson was 50 years old when he was killed 10/13/2016 by Las Vegas Metro. After LVMPD disabled his vehicle, already missing a tire, they immediately opened fire on Rex. All these people I call and talk about who have lost their lives to police are human beings, somebody's loved one. Rex married Petra Gonzalez in Rapid City, South Dakota on August 27, 1988. In December of 1988, he joined the United States Marine Corps and was assigned to duty at Camp Pendleton until 1994. In 1995, him and his family moved to Henderson. The excited young couple immediately began to follow their dreams of expanding a large family. They were blessed with 10 beautiful and amazing children: Mario, Aaron, Alex, Haven, Jesse, Haley, Hermione, Matthew, Helena, and Elijah. He and Petra were dedicated parents. Rex Wilson was a loving, dedicated father and husband with a great sense of humor. He was a family man who was present at all important functions of his children's lives and also enjoyed family gatherings such as holiday celebrations, attending his children's sporting events, being a voice of guidance for his children. He graduated with a BA from the University of Phoenix and was a successful businessman during the time he lived in Henderson. Rex was a proud Oglala Sioux tribe member. Please support bills like SB 50 and AB 157 that promote transparency and accountability. Please do not support bills like AB 92 or AB 127 that proposes hiding police identities from civilians who they are meant to serve. Passage of AB 127 would mean lowered accountability for police officers who murder or assault civilians. Thank you. Have a nice day.
Thank you for your public comment, Ms. Grant. BPS, are there additional callers for public comment?
For callers wishing to provide public comment, please press *9 now to take your place in the queue. Chair, the public line is open and working. However, there are no further callers at this time.
Thank you so much, BPS. I will close public comment. Anything else from committee members this morning before we talk about the rest of this week? Right, I don't see anything. Thank you, committee members. We have now cleared out all the Senate bills that we have in front of us. Well, I take that back. We cleared out 3 of them. I think we have a couple more that we may be able to hear tomorrow, but that's all we have in the committee right now. So we'll see if we get some more Senate bills on the floor today. I suspect we will. In terms of where we go from here, we are going to have a meeting tomorrow. It's going to be at 9 o'clock rather than 8 o'clock, and we're going to hear either one or two bills. I'm just trying to get confirmation, so I'll get those to you as soon as I can. And we are going to be back in the committee room tomorrow. So this will be hopefully our last virtual meeting of this kind. So remember, 9 o'clock tomorrow in the committee room. If you don't know where the committee room is, feel free to ask one of us who've been in there. I know we have a lot of new members on the committee this session. And then in terms of Friday, I don't know yet whether we're going to have a meeting on Friday. It kind of just depends what we might get on the floor today. And likely next week, we'll probably end up canceling Monday and Tuesday due to having longer floor sessions, but I'll get confirmation of that as well, and I'll let you know as soon as I know. So committee, will see you back in the committee room tomorrow morning at 9 a.m. I hope everybody has a great rest of the day. This meeting is adjourned.